In re Aviles, Brent D. Meyer appearing for Chapter 13 trustee appellee Lillian Tsang.
Okay, Mr. Meyer, please go ahead.
Yes, good morning, or good afternoon, if it may please the court. My name is Brent Meyer, and I represent Lillian G. Tsang, Chapter 13 trustee, successor Chapter 13 trustee, and appellee in this matter. This is a fairly straightforward case before this court, but the procedural aspects of it create a little bit of uncertainty or an anomaly. And I think that's really where the focus should be on, is why we're here and how we got here. But before I begin, I think there's two important things to note. Number one is that the debtor appellant failed and refused to file a reply brief, for which we would submit that they have waived arguments in response to the trustee's brief. And second is that the appellants also refused to appear before this panel and argue on the merits of their appeal. And I think that speaks volumes, and why it speaks volumes is specifically because I suspect this court would have significant questions for counsel regarding admissions that he made on the record when the court determined that it would convert the case back to Chapter 13.
Counsel, go ahead. Sorry, Mr. Gann, go ahead, please.
I was going to just ask you, isn't it equally plausible that it's expensive for someone to appear and that they'd have to pay a lawyer, and they already made their position clear by their brief, so they didn't need to do more than that?
I actually would submit otherwise. The fact that we are on a Zoom hearing today and the cost of appearing at 15 minutes or 30 minutes before this court on Zoom, it's really not a burden to the debtor, specifically given what's at issue in this case. And so I think that it also speaks volumes that they just elected not to be here to provide their position to this court.
Well, I guess another question I have is why is the Chapter 13 trustee here? Because the Chapter 13 trustee didn't object to the debtor's motion to vacate the conversion to Chapter 7. Isn't that right?
Can you rephrase it?
What he is saying is the 13 trustees' only objection was on the basis that they are sensitive to foreign language debtors and that they, in fact, do provide that kind of service. He did not say he had any objection to the motion that the debtor filed seeking relief from the conversion order.
Well, if you're referring back to the original motion to reconvert to Chapter 13, at that point,
I think we have an issue with what that motion was, but go ahead.
Go ahead. I agree that there's a question of how that motion was styled, what the relief was, and what the relief was granted from that motion.
There isn't really a question, is there? The motion is styled as a motion under Rule 60. The court states that it's a motion under Rule 60. It was docketed as something else, but there's nowhere in the motion that it discusses anything other than Rule 60.
Well, the actual motion to reconvert, or the original moving papers for which the debtor sought to get from Chapter 7 to Chapter 13, it was styled as a motion under 60B. However, when you look at what the court did
Who cares what the court did? What the debtor sought was relief under Rule 60. The court could deny it. The court could treat it as a different motion if it stated so. Did it do that?
Well, I believe in the civil minute order, the court did acknowledge that the debtor was not entitled to relief under 60B because in the court's own opinion, he thought that it exceeded the bounds by which relief under 60B would be granted on that record. And
he said it stretched it to the breaking point. Did he ever deny the motion specifically?
I believe that
He did not. The record is clear that he granted the motion. That's what's at the top of the document. It's what's in the substance of the minutes themselves. It says the motion is granted.
Well, but if you look at the order, which is excerpt of the record 92, the order that was actually prepared by debtor's counsel uses the word reconvert. So there's a lot of ambiguity around what actually happened and what relief was actually granted, but the court was not.
Let me ask you about that. Isn't it by operation of law that if the court grants relief from the conversion, the case automatically reconverts to Chapter 13? By operation of law.
If
Would
the
you
court
vacate the conversion order?
If the court vacates the conversion order, then the case was never in a Chapter 7, and so we're only talking about a case that's in a Chapter 13. But then that begs the question is, if you vacate an order and by operation of law the case was never in a Chapter 7, why would the court go on to analyze that the Chapter 7 trustee agreed to the relief provided that his fees were paid in the amended Chapter 13 plan? The court would have, you basically have a situation where if you take for face value what the debtors are trying to argue here, the Chapter 7 trustee would have then opposed the motion, but in order to win over the Chapter 7 trustee, the debtors agreed to pay them, but then they would have turned around and said, well, we're going to right away turn to move to dismiss the case under 1307. That's just...
Excuse me, counsel, what fee was owed to the Chapter 7 trustee at the time of the conversion?
Well, they agreed that he was not entitled to...
What fee was owed is what I'm asking you. Under 326, what amount of money would have been due to the Chapter 7 trustee?
It would have been on an hourly lodestar rate, and it would not have been in the commissions under 326 was the position of what was agreed to on the record.
But he's not entitled to an hourly lodestar rate. He's only entitled to 326 commissions.
Well, I mean, suppose there had been no agreement. Suppose there was no agreement. Would the Chapter 7 trustee have had any entitlement to any fee?
I think the Chapter 7 trustee would have opposed the motion at that time on those facts. And so what we have is whether or not the Chapter 7 trustee is entitled to a 326 commission, an hourly rate lodestar, or indifferent, whatever amount he may or may not have been entitled to, the Chapter 7 trustee opposed the motion. And in order to resolve that opposition, the debtor agreed to pay him a $5,000 fee as a Chapter 13 administrative expense in the plan. The trustee never got to argue his position and have the court rule on whether or not the debtor was entitled to 60B relief or whether he was entitled to convert the case. The court simply said, or the Chapter 7 trustee simply said, I will withdraw my objection if you provide a $5,000 fee, period. That is,
well, you know, I have to say that I'm troubled by the Chapter 7 trustee's position, and I recognize you don't represent the Chapter 7 trustee, but it still bothers me because basically the Chapter 7 trustee is supposed to be looking out for the interests of the estate. He got paid a personal fee and said, okay, I'm done. You know, that takes care of my concern. Whatever happens to the trustee's fiduciary duty to the estate?
Well, so I think that's easily answered is because this was a case for which there was 100% recovery on each dollar because of the non-exempt equity in the house, that whether it was in a Chapter 7 or a Chapter 13, all creditors were going to get paid in full. So
what's the basis? What would have been the basis for the Chapter 7 trustee's objection to the motion to get the case back to 13, however you phrase that? I mean, if the estates or the creditors are in the same place either way, the only person who loses out is the trustee. The trustee is not acting for the estate anymore, it seems to me.
But you have to take back, and who loses is the creditors lose in this case, because what will happen is the debtors wanted to get back into Chapter 13 so they could turn around and dismiss the case. And once the homestead exemption now is in a higher amount, they would have refiled a new case and they would have paid a less dividend to unsecured creditors. The entire system is predicated on the fact that the debtors in the underlying Chapter 13 were required to pay 100% dividend to unsecured creditors. And once it was converted to a Chapter 7, the Chapter 7 trustee would have recovered and paid 100% dividend to unsecured creditors.
So let me ask you a question, counsel. If the case hadn't been converted, but instead it had been either dismissed or there'd been a hearing conducted on the motion by Trustee Myers to have the case dismissed, the debtors could have, under 1306, 1307B, immediately moved to dismiss the case.
Well, yeah, that could be true, but that's a different fact pattern. Is if the debtors would have affirmatively moved to dismiss the case, they could have done so. But the court,
but they didn't have notice. That's what they claimed. They didn't have notice. They didn't understand the notice. Their counsel had been disbarred or suspended. That's not in dispute. The Chapter 13 trustee, and that was in 2021, the Chapter 13 trustee didn't move until 22 or 23 to have the case converted or dismissed at that point when the payments hadn't been made. There was no attempt, seemingly, to get these people a hearing before the case was converted.
Well, I can't speak for what debtors counsel would have done or should have done. The reality is that the court, on the motion by the Chapter 13 trustee, determined under 1307 that it was 1307A that it was in the best interest of creditors to convert the case to a Chapter 7. That was the motion before the court. That is what the court did, and the debtors did not oppose that relief. Whether or not they should have gotten new counsel, should have argued it, those are all questions for which there could be a claim for professional negligence or whatnot. But the court went out of its way to say that the Chapter 13 trustee was not required to provide Spanish interpreter for this services. And so it's quite disingenuous for the court to insert that the Chapter 13 trustee should have went above and beyond its duties to provide additional legal advice to a Chapter 13 debtor for which they were represented by counsel. Mr. O'Gillis was still getting the CMECF notices, although he was disbarred. He was getting the notices, and he elected not to do anything until after the Chapter 7, the case was converted to Chapter 7.
So you're suggesting that a disbarred lawyer ought to act as a counsel for someone when it would be against the law? He'd be practicing law without a license, that's what he should have done, and that the Chapter 13 trustee who knew he was disbarred and was receiving notices shouldn't have asked for a hearing to be conducted? I'm not suggesting that a Spanish language interpreter should have been provided. What I'm suggesting is the case should have been immediately converted by the court if the Chapter 13 trustee had said their lawyer is no longer practicing. We're not clear that these people have actual notice of what's going on. Let's have a hearing, Your Honor. Then we could determine what the facts are, but that didn't happen in this case. That's where my concern was. But my larger concern is where in the transcript, where in the minutes is 706A described by the court at all? The statute discussed anywhere. Where in the order is 706A described? The only kind of relief that could be granted after conversion is with discretion of the court. Where is the court's discretion described? Where does he say, I'm doing this on the record because, and these are the factors I'm considering? None of that appears anywhere, does it?
If you look at the actual transcript of the record, that's where the court actually cites 706A and the fact that he's granting conversion. The court is granting the motion to reconvert the case and acknowledging that the debtor does not have the right to then, under 1307A, turn around and voluntarily dismiss the case. Why would the court go have that discussion with debtor's counsel on the record if the court was doing anything other than reconverting the case? It simply is illogical to suggest otherwise.
I don't disagree with you, but then why doesn't the order reflect the discussion of 706A? Why don't the minutes discuss a reflection of 706A? Why doesn't the court's order that grants the relief discuss 706A? That doesn't appear anywhere in any of those documents either. How is that consistent with the court's? I also don't see a motion by the debtors, orally or in writing, to convert the case under 706.
Well, I think the same argument could be made that the order itself doesn't reference that it was granted under 60B or that the order was vacating. So, I mean, I don't think you can suggest that because the absence of 706A in the order, that therefore it necessarily had to be granted under Rule 60B. That is inconsistent with the transcript, and the order was not prepared by the court. The order was prepared by Mr. O'Toole, and the court then entered that order. And so it's, when you take
the order itself says the matter that came on for hearing is a motion for relief from the order converting it to Chapter 7. The minutes are the findings of fact, good cause appearing, it is ordered, the motion is granted. It doesn't say under 706, it doesn't say that I'm exercising discretion, it doesn't say anything like what the transcript suggests, and there's no oral motion at the hearing to convert the case under 706. All we have in this record is a record under Rule 60B.
I think we may respectfully just disagree on, I acknowledge that the motion was styled under 60B, but when you read the actual civil minutes issued by the court, it said that there is no fact or basis for which the court is going to take the relief under 60B, and that everything that the court did after that time acted as if they were moving to convert the case under 706, and that there was no right to dismiss the case. If we're going to take,
so let's go to the actual order, that minutes that say the court says that in fact the only discussion of the law that's even in the minutes at all is under 60B, and he says that the excusable neglect standard is what's applicable. That said, the court would note that the motion is based under Rule 60B. There's no discussion of 706, which requires a showing mistake, inadvertent, surprise, excusable neglect. And in the court's view, the debtor's decision, and he details 1 through 3, which are the decisions of the debtor, all stretch the bounds of excusable neglect, quote, nearly to its breaking point. But the bankruptcy court does not deny the motion or say that the debtor has failed to establish the relief that's requested, and therefore the motion is denied anywhere in the minutes. Does he?
I don't believe that the minutes accurately reflect the order of the court for which the hearing and of the transcript that has been presented are consistent with one another. And that is part of the problem that we have here.
What controls? Does the oral statements at the court not incorporated into the order control, or does the order control when you have an inconsistency?
Sorry, I'm having a little difficulty hearing you with the audio.
She's saying, does the court's oral statements control over the written order or vice versa? In other words, if a court said one thing at a hearing and said something different in the written order, which would control?
That is a difficult question. We have a record here that is, the court was led down a different path at the hearing for which the actual motion was made. The civil minutes were entered as a tentative ruling before the hearing, and then we have an order that comes out of that hearing which recites slightly different facts than what it actually was heard. And so I think that the way that this court can actually tell what the court was thinking at that hearing, where if you look at the motion for a stay pending appeal and a motion for reconsideration of the motion vacating the dismissal of the case, this court can have an actual record reflecting what the bankruptcy court thought it was doing at the time during the hearing. The fact that there is some anomalies with the civil minute order, the hearing transcript, the motion itself, those are all niceties, but this court, as it sits here today, can take a look at what the bankruptcy court was thinking when it ruled all along the way, because the court has spelled out in 15-page opinions on 2 different occasions what it was doing and why it thought that it was the proper mechanism for which it was doing. I think that speaks volumes for this court to ascertain what Judge Lestretto was thinking at the time that the motion to reconvert, or 60B, was before it, and all subsequent steps after that. It is very clear that Judge Lestretto was not granting relief under 60B. He was allowing reconversion under 706A, and the debtor did not have an absolute right to dismiss the case. The record reflects that clearly.
Thank you very much. We've taken you past the 15 minutes with a lot of questions, and thank you very much for your excellent argument. The matter is submitted. We'll get a written decision out promptly. Thank you.
Thank you.